Gary DeWaal here, and this is Bridging the Week for July 20th to 24th, and today is July 27, 2015. Good morning. 27 disciplinary actions brought by the CME Group touching upon EFRPs, transfer trades, money passes, position limits, block trades, and disruptive practices provided an abrupt reminder that a failure to comply with relatively technical rules can result in fines as well as corporate distraction while employees address regulatory inquiries and actions. Moreover, the book on the fate of customers, secured creditors, and unsecured creditors of MF Global Inc., the defunct FCM that went belly up in 2011, appears to be finally closing with a relatively good outcome under the circumstances. We have many interesting articles to cover this week, so let's get started. CME Group handed down sanctions in 27 disciplinary actions last week for offenses including alleged violations of rules related to exchange for related positions, transfer trades, money passes, position limits, block trades, and disruptive practices. Among the most material matters, wholly owned subsidiaries of International FC Stone Inc., including International FC Stone Markets LLC and International Commodities Inc., received the largest number of individual sanctions, 8, and total fines, $160,000. Generally, the entities were charged by CME Group with violating rules related to EFRPs, typically by having no or insufficient documentation for related position, or in one case, by not transferring ownership of the related position. The alleged violations occurred on various dates in 2013 and 2014. With limited exception for EFRPs involving foreign exchange, all EFRPs on CME Group entities must involve the bona fide transfer of a related position from one party to another documented in accordance with market custom. Goldman Sachs Execution and Clearing LP was sanctioned $110,000 by the Commodity Exchange Inc. for allegedly facilitating the transfer of gold futures and option positions between two customers with different beneficial ownership without exchange approval on February 27, 2013. A CME Group exchange must approve the transfer of positions between accounts of different beneficial owners when the transfer is in connection with a merger, asset purchase, consolidation, or other non-repetitive transaction between two or more entities. And finally, Katten Muchin was sanctioned $35,000 in total by each of the four CME Group exchanges in connection with an alleged money pass from an account owned by his employer to his own account. According to CME Group, Muchin organized the transfer through 23 round-turn transactions across the four exchanges between May 27th and 30th, 2014. CME Group prohibits the execution of transactions for transferring equity between accounts. In connection with this matter, Mr. Muchin was also prohibited from trading any CME Group products for 10 business days. Each of these matters was resolved voluntarily by settlement by the respondents. Unsecured general creditors of defunct MF Global, other than those of its parent company, MF Global Holdings, will receive a final payment from the firm, giving them a total recovery of 95% of their approved claims under a proposal made last week by the overseers of the liquidation of the firm and its parent company, MF Global Holdings. Previously, customers of MF Global received back $6.7 billion or 100% of their allowed claims. Secured, administrative, and priority claimants received back $22.3 million or 100% of their allowed claims, and unsecured general creditors received back $991.6 million or 74% of their unsecured claims. Previously, the CFTC filed an enforcement action, which is still pending, against John Corzine, CEO of MF Global, and Edith O'Brien, Assistant Treasurer of the firm, claiming that MF Global Holdings and the two individuals failed to segregate and misuse MF Global customer funds. It is very good that the financial repercussions of the collapse of MF Global Inc. on customers and creditors appear likely to be mostly resolved by year-end. However, this resolution does not lessen the near hysteria experienced by customers and creditors that immediately followed in the days following the demise of the firm, a demise apparently instigated by unplanned for regulatory requirements related to proprietary investments and the catastrophic breakdown of systems and controls. Jay Grossman, a Florida-based attorney, settled an enforcement action brought by the Commodity Futures Trading Commission related to alleged aiding and abetting of multiple clients in their operation of illegal precious metal schemes for retail clients. These firms included Hunter Wise Commodities LLC and related entities. Each of the firms assisted by Mr. Grossman previously has been subject to orders by federal courts finding that their precious metal transactions violated applicable law. Among other matters, the CFTC charged that Mr. Grossman, quote, helped defraud retail customers by preparing documents, including account agreements, that he knew would deceive customers throughout the life cycle of their retail commodity transactions, end of quote. Mr. Grossman settled his action with the CFTC by agreeing to pay a fine of $150,000 US and restitution of $733,000 US. And finally, the International Swaps and Derivatives Association has published an overview of milestones in connection with the requirements of the Dodd-Frank Wall Street Reform and Consumer Protection Act that was enacted over 5 years ago last week. Among other things, the report highlights that during the first half of 2015, 75% of the average daily notional volume of interest rate swaps was cleared, while 78% of the average daily credit default swap index notional value was also cleared. In addition, 55% of interest rate derivatives and 65% of CDS index average daily notional volume are now executed on swap execution facilities. Going forward, says ISDA, there needs to be better global harmonization of national rules to avoid market fragmentation. More work needs to be done to ensure central counterparties are resilient. Greater flexibility in execution methods should be introduced to the SEP regime, and standardized product and transaction identifiers and reporting formats must be adopted globally to help regulators gain a clearer picture of global risk exposure and concentrations, among other recommendations. Well, that's it for this week's issue of Bridging the Week. As always, there's more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week, and ciao!